Moot officer is this. Our volunteer. Time. Okay, very good. Very good. March. Yes, ಎಲ್ಲರೂ ಉಟ್ಕಾರು. Please be seated, everyone. I just remember my old days where we never had witnessed actually all students sitting without making any noise actually. We have, nobody could discipline us actually. That was the moral we have been taught everyone. And I wish you all success in your career, and particularly the finalists, all three plus three, actually I wish them success, do well. So even will enjoy actually when you lose a case before court. Suppose if you fulfill, so that is the spirit, that's all. It is not as if actually you should always win. And then the efforts, the time which you have spent, the many things, in the process of actually exposing the cause of actually our litigant, we learn a lot. We learn a lot. And every experience we gain is going to be the asset in you that will help in building actually the judiciary. Therefore, this is what I want to convey. Thank you very much, and we'll watch you doing this because we don't want to embarrass. Because my presence sometimes actually may embarrass you, and you will sometimes tend to forget what you wanted to, and then this is the way. Yes, I come back a little later. Thank you.
independently. We will decide the judge, then we will. Let them explain. Let them explain. Thank you. Please, please. Good afternoon. Yes, you can announce.
Now the case is before the Honorable Supreme Court of Bharadam. The matters between the Democrat and NGO as appellant, the Union of Bharadam as respondent. Now the court is in session. The appellant said you can start your arguments, right?
Yes, counsel, please.
Good afternoon, Honorable Bench. The Council most humbly recognize the gracious presence of my ladyship, but for the purpose of proceedings, the Council most humbly seeks to collectively represent the bench as your Lordships. Much obliged, Your Lordships. My Lordships, the Council most humbly seeks permission to submit the compendium before this Honorable Bench.
Yes.
Much obliged, my Lordships. And environmental activists versus Union of Bharadam. The Union of Bharadam is the 7th largest populated and South Asian country. It has various biological diversities such as flora, fauna, rivers, lakes, plains, plateaus, mountains, and reserve forests, my Lordships. My Lordships, the Union of Bharadam has various diversities. Despite of those diversities, Union of Bharadam follows the principle of unity in diversity. My Lordships, in the Union of Bharadam, there is a state called Tainadu, which is the southern state of Union of Bharadam. In this state of Tainadu, there are two cities, which is Silver Star and Puhar. The Union of Bharadam, the Union government of the Bharadam decided to connect those cities in the year of 2021 and proposed the project of Greenfield Expressway Corridor project with the amount of 15,000 crores, which extends up to 263 kilometers, out of which 45 kilometers of the forest have 45 kilometers of the highway passes through the Idikal Reserve Forest. Due to this highway which passes through the Idikal Reserve Forest, the Senjan tribes who were in the forest time immemorial have been dislocated from the forest, my Lordships. The Democrat, an NGO on behalf of the Senjan tribes, have filed a public interest litigation before the Honorable High Court of Tainadu, where the Honorable High Court of Tainadu has dismissed. The Democrat appealed before this Honorable Supreme Court, where the Democrat and NGO should be considered as appellant one in this case, my Lordships. My Lordships, on other side, after the government has completed 50% of work in this project, after completing 50% of work, the government has applied for the post facto clearance, which was challenged by Ms. Varshi, a law student and environmental activist, before the Honorable National Green Tribunal of Union of Bharadam, where the National Green Tribunal also dismissed the petition. She approached the Honorable Supreme Court, where she is appellant to in this case, my Lordships. My Lordships, the Honorable Supreme Court have clubbed both the petitions and posted hearing. The issues arised in these facts are, my Lordships, whether the acquisition of land from the Sengan tribes have violated their fundamental rights, and whether the construction of this project without environmental clearance is justiciable, and whether the said project is in violation of coastal regulation zone notification, my Lordships. My Lordships, Myself, Appellant Counsel Speaker 1, will be dealing with the maintainability of this appeal and issue 1 in this case, my lordships. And my co-counsel will proceed with the other 2 pleadings, my lordships. Much obliged, my lordships. My lordships, if this honorable bench permits, the counsel most humbly seeks permission to state the jurisdiction in this case, my lordships. Much obliged, my lordships. My lordships, the Democrat, an NGO, and Ms. Varshi, a law student, has approached this Honorable Supreme Court under Article 136 of the Constitution, where Article 136 provides every citizen of the Bharadam has the right to appeal before the Honorable Supreme Court when they are not satisfied with the judgment or when they are aggrieved with the judgment.
Counsel, Article 136 speaks about rights of citizens or rights of persons?
My lordships, it speaks about right of persons to my lordships.
Okay, thank you.
Much obliged, my lordships. My lordships, where every person has the right to approach the Honorable Supreme Court under Article 136, which the Article 136 guarantees that any party can appeal before this Honorable Supreme Court when they are not satisfied with the judgment or when they are aggrieved with the judgment which was given by the subordinate courts, which includes high courts and tribunals, my lordships. My lordships, here the council most humbly submits that first, the Democrat and NGO approached the Honorable High Court where the petition have been dismissed by the High Court, and on other side, Ms. Varshi, a law student, has also approached the National Green Tribunal where the petition also dismissed by the Green Tribunal, and as the last both the parties have approached this Honorable Supreme Court, and the council most humbly submits that we have exhausted all the available remedies and as a last hope of justice appeared before this Honorable Supreme Court, my lordships. My lordships, the council most humbly seeks permission to proceed with the issue 1. Much obliged, my lordships. Issue 1 in this case is whether the acquisition of land from Sinjan tribes have violated their fundamental rights. My lordships, the council most humbly submits that there is a mass violation in the fundamental rights of the Sinjan tribes in the acquisition project, my lordships, as the Sinjan tribes were in the forest time immemorial, their livelihood depends upon the forest, their lives depend upon the forest. If they have been dislocated, then their livelihood, life are in question, my lordships. The council most humbly submits that the acquisition of land from the Sinjan tribes have violated Article 19 subclass 1 Article 19 subclass 1E of the Bharadam Constitution and Article 19 subclass 1G of the Bharadam Constitution, which also violated the Article 21 of the Constitution, my lordships, where Article 19 subclass 1E is every citizen has the right to reside and settle in any part of the territory of Bharadam, where Article 19 subclass 1G is every citizen has the right to practice any lawful occupation, my lordships. My lordships, the council most humbly states that when these Sinjan tribes have been dislocated, they have lost their place where they have been habitated from the time immemorial, and they have also lost their occupation, my lordships, as in the facts it has been stated that collecting minor products from the forest and selling all those is their occupation, my lordships. If they have been dislocated, it's very difficult for the Sinjan tribes to collect the products from the forest and sell it, my lordships. My lordships, the council most humbly seeks permission to submit the case of Volga Teles versus Bombay Municipal Corporation, where this Honorable Supreme Court has said that Article 21 of the Constitution, which also includes right to livelihood, my lordships, where these Sinjan tribes have been dislocated, their livelihood is in question, my lordships. My lordships, the council here also highlights the case of Menaka Gandhi versus Union of India, my lordships, where the Honorable Supreme Court has held that Honorable Supreme Court has laid a great principle, that is golden triangle principle, my lordships, where if there is any one violation of article in Article 14, 19 or 21 of the Constitution, the other 2 articles will be automatically violated, my lordships. My lordships, the council would also like to submit the case of MC Mehta versus Union of India, which is famously known as Taj Trapezium case or Taj Mahal case, where the Honorable Supreme Court has held that right to life and personal liberty is a wider fundamental right available to the citizens, available to other country citizens too, my lordships, where the Honorable Supreme Court held that right to environment is also a fundamental right under Article 21 of the Constitution, my lordships, where in the case of Subhas Kumar versus State of Bihar, the same has been held, my lordships. My lordships, the council most humbly states that the land acquisition which was done by state also violates the section 2 of Prevention of Atrocities Act against SC and ST, my lordships, as the council states that the state has enacted the law where the state itself violates the act, my lordships. The main aim of the act is to protect the scheduled caste and scheduled tribes, my lordships, where the council humbly submits that.
Council, moving further, let me make 4 specific clarifications.
Much so.
You are standing before the honorable bench to claim your fundamental rights or fundamental freedom.
My lordships, fundamental rights, the council is here.
Which specific fundamental rights of Bharadam Constitution is violated, council?
My lordships, Article 19(1)(e), Article 19(1)(g), Article 21 and Article 14 have been violated in this land acquisition process, my lordships.
19 is a fundamental right or freedom, council? Is it absolute or restrictable?
My lordships, Article 19 is a right to freedom of speech and expression, my lordships. The freedom has certain the freedom under the concept of freedom.
Is it absolute or restrictable, council?
Much obliged, my lordships. My lordships, this under the Article 19 subclass 1 subclass G has its own restrictions in Article 19 subclass 5 of the Constitution, where the state can impose certain restrictions upon those articles, but in the Constitution itself it has been stated that in Constitution
whatever freedom you demanded by referring 19(1) subclass E and 19(1)(g) is subject to restriction.
Much obliged, my lordships. The council, before stating that, answer this, my lordships. Where in the Article 19 subclass 5 of the Constitution, it has been mentioned that the state can impose certain restrictions, but it should not violate the rights available to the scheduled tribes, my lordships. Where in the Constitution...
Yes, council. What right is violated?
My lordships,
Which
here...
specific fundamental right is violated? How it is otherwise derogated by exhausting land acquisition, council?
My lordships, here the right under Article 19(1)(e) and right under Article 19(1)(g) have been violated, my lordships, as the state has acquired our land. As the state has acquired our land for the state project, they dislocated us from the...
Do you have a fundamental right or fundamental freedom of property, council?
My lordships, fundamental right of a property is not a fundamental right, my lordships. But as per the sections of Forest Dwellers Act, the scheduled tribes are a people who are living in the forest as not to be dislocated.
Which forest's land is taken away or acquired according to the Kambarami Council?
My lordships, Idikal Reserve Forest has been acquired in this.
Reserve forest, is it an area to make your freedom?
My lordships.
Whether reserved forest,
Indeed,
is it a permissible area to exhaust your fundamental freedom?
My lordships, but the scheduled tribes is as to be considered as the owner of that land as they were in the forest time.
Where is a supporting document? Where it is mentioned the scheduled tribes are owner of the reserved forest land.
Much obliged, my lordships. The council would like to state land laws, my lordships, as in the land laws, if a generation is more than 4...
No, land laws, it's a law. Is there any act or is there any section from any law? Because you beautifully mentioned 21.
Indeed, lordship.
Please read Article 21. What does it say?
My lordship, Article 21 says that right to life and personal liberty.
No, you read exact line. The state, no person shall be deprived of his life or personal liberty except according to procedure established by law. Where is a law, council?
My lordships, here they acquired our land and our livelihood is in question, my lordships. We are without food for...
Your livelihood is questioned. Yes, we bench is ready to agree.
Indeed,
your
lordship.
livelihood is affected in furtherance of what law which is made by Bharadam.
My lordships, as per the sections of Forest Dwellers Act, we have the right to reside in the forest.
Which section? Substantiate.
Much
Which
obliged,
section of Forest Dwellers Act is violated?
Much obliged, my lordships. Section 4 subclass 5 and section 5 of the Forest Acts has been violated, my lordships.
Which year? You are mentioning PESA or you are mentioning 2006?
2000.
You are mentioning 1927? Which act? You read.
Begging your pardon, lordship, the council here submitted the Act of 2006 Forest Dwellers Act, my lordships. As in the Forest Dwellers Act, it has been stated that section 5, it has been stated that no scheduled tribe should be dislocated from the forest or deprived from the forest unless the project has been recognized and completed, my lordships, where they, after completing 50% of work, only applied for the post facto clearance.
No. we will discuss the second issue, third issue later.
Much
First, which
obliged.
fundamental right is violated?
My lordships, the council most humbly submits that Article 19(1)(e), 19(1)(g), 21 have been violated in this by acquiring the land, my lordships. We mostly,
again
my
you
lordships,
read-
as we are poor tribal people, we depend upon the forest. We collect the,
Council, you read 19.5 and 19.6. Please list what all reasonable restrictions are there.
Much
You
obli-
take your barrack and read.
much obliged, my lordships. As per 19 subclass 5 of the constitution, every, the state
No,
has,
Council, you read the barrack. We bench encourage you to open and read.
my lordships,
We don't describe, you read.
Bar Act is with my
Please
research.
get it from your own researcher. Yes, any member leave can. Public order, decency, you read.
My lordships, in article subclass 5 of the constitution, it has been mentioned that nothing in subclass D and E of the said class shall affect the operation of any existing law insofar as it imposes or prevents the state from making any laws imposing reasonable restriction on the exercise of any of the right conferred by the said subclasses, either in the interest of the general public or for public protection of interest of any scheduled tribes.
Right.
Much obliged, my lordships. But the council is unaware that how here the public.
No, don't make us, because you are a council representing two parties.
Much obliged.
When you say unaware, can we postpone
My
the
lordships,
case,
the
adjourn
council
case?
most humbly submits that the council here is dealing only with the first issue, which the council impliedly represent the Shenzhen tribes, my lordships, and my co-council will be
Yes, very
representing.
good. Then you brought very interesting aspect of Atrocities Act.
Much obliged, my
The
lordships.
acquisition of a land is a civil dispute or criminal dispute, council?
My lordships, it's a civil dispute, my lordships.
Then
My lordships, the council
which section of atrocity you are referring? Yes.
much obliged, my lordships. As per section, my lordships, as per section 2 of the Prevention of Atrocities Act 1989, the Bar Act itself, it has been mentioned that wrongful disposition of a tribes, wrongful disposition or wrongful dislocation of a tribe from their dwelling place is also considered to be atrocities against them, my lordships, where the state has dislocated us intentionally and forcefully to complete their project, my lordships.
So according to you, council, taking the land for public purpose, it's a wrongful, right?
Indeed not, you lordships. The government has the right to take the land, but it should properly provide us, it should properly uphold our rights too, my lordships.
Where your rights are mentioned?
My lordships, as
Saying uphold your rights, yes. We bench is ready to uphold your rights. Where it is mentioned, where it is conferred?
my lordships, the fundamental rights are guaranteed that every citizen has right to reside and settle in any part of country. Every citizen has the right to practice any lawful occupation. Where in the Moot proportion it has been stated that the Shenzhen tribes are dwellers of forest, edible reserve forest from time immemorial, which means they are.
Which paragraph number says so?
My lordships, may I get Moot proportion from my researcher? My lordships, may I continue, my lordships? I will state when my research. Much obliged.
You have a right from time immemorial.
Yeah, indeed, lordship, indeed, lordship. Page number. எங்க மென்ஷன் பண்ணிருக்காங்க பக்கத்து புறாமே my lordships, in the last proportion of in the last paragraph of Moot proposal 8, my lordships, it has been stated that the Shenzhen tribes who are the native of Idikal Reserve Forest has been enjoying the indigenous right of the Idikal Reserve Forest since time immemorial, my lordships. My lordships, if the bench is convinced, my lordships. Much obliged, my lordships. As these Indian tribes have been in the forest from time immemorial, their livelihood, their occupation, their dwelling place, all resides upon the forest, my lordships. When they are dislocated, all the rights have been violated, my lordships. My lordships, the bench is convinced with the fundamental rights violation, my lordships.
You can continue.
Much obliged, my lordships. My lordships, the council here would also like to state that right to fair compensation, rehabilitation, resettlement act of 2013, section 41 subclass 1 states that no land can be acquired from these scheduled tribes, where subclass 2 states that even though if the land should be acquired from the scheduled tribe as a last demonstrable resort. Where in 41 subclass 3 it has been stated that the state should get proper consent before acquiring the land from the Gram Sabhas which the forest comes under, my lordships. Here the council would also like to state that the case of Odisha Mining Corporation versus Ministry of Environment and Forest, where the Honorable Supreme Court has held that the prior consent from the Gram Sabha is necessary before acquiring the forest, my lordships. Here the government...
Council, whether here government is acquiring the land or giving a license for mining. What is the
Here
relevance
government
of this case?
acquiring the land, my lordships.
What is the relevance of mining case here? Mining is done under what act, council?
My lordships, it's done under Mines Act. The council is not aware of the Mining Act, my lordships.
You only said Odisha mining case. We never introduced a new case to me.
My lordships, in this case, the council would like to submit the ratio decidency of this case as per the doctrine of precedence. The council requests the honorable bench to consider the ratio decidency in that case, my lordships.
Okay, is it a case decided by the 7-judge bench?
My lordships,
Which article says whether the Supreme Court has to accept the decision given by the court? Because we are a full bench, you are bringing a case.
my lordships, as per a doctrine of precedent, the bench with its discretionary power, my lordships, the council requests with the bench with its discretionary power to may consider this case.
Whether a constitutional court has any discretionary power, council?
My lordships, if the lordships wishes, they can...
Where it is mentioned?
My lordships, as per doctrine of precedent, the council has stated.
Which article, council? We are the bench constituted because of Karadam constitution. When you are saying something, then we are also to check. Where it is mentioned?
My lordships, the council is not aware of the begging your most humbly begging.
Continue.
Much obliged, my lordships. My lordships, the council would also like to state that the Judicial Reserve Forest is a elephant corridor, my lordships, where the elephants, where this earth is not only for the human beings, my lordships. Elephant or other living beings, other wild animals has the right to reside and settle in this area, my lordships, where the animals have came to this earth before human have came to this earth, my lordships. In this Moot proposition, it has been stated that Judicial Reserve Forest is an elephant corridor, which means the elephant is the forest is reserved as there many elephants exist in that place. When this highways project has been completed, when the roads has been laid down, there may be a faster transportation which may hit the animals. 1 second, my lordships.
Page number 14, paragraph number 8.
Indeed, lordships. Lex specials derogate lex, which means special laws repeals general laws. This maxim entitles that when the two norms apply to the same subject matter, the rule which is specified should prevail and be given priority over general, my lordships.
Okay. What is the law you are referring by?
Indeed, lordships. The council here refers the LARR Act and Forest Dwellers Act, my lordships. As this Forest Dwellers Act 2006 has been enacted in view to protect the scheduled tribes, in view to protect the forest dwellers, it is a special law, my lordships, where the land acquisition, which means right to fair compensation, right to transparency, Fair Compensation, Rehabilitation and Resettlement Act 2013 is a general law. The special law prevails over it, and the government may consider that the lives of these engines have been in burden as when they are acquired the land from these engine types, my lordships.
Last and final clarification.
Much obliged, Lordships.
So according to the Bharadam constitution, whether state is empowered to acquire a land or not?
My Lordships, the state can acquire the land, but it has to follow some procedures where the state has not followed any such procedure. They, the Senjan tribes at the initial stage conveyed their
Procedures are referring under which law council?
My Lordships, procedures are referring under Article 31A of the Constitution, my Lordships.
Article?
31A of the Constitution, where the state has the right to acquire a state which has been established in Land Acquisition Act, my Lord, LARR Act 2013, my Lord.
That's what. LAR Act expects what all procedures have to be complied as and when lands are about to acquire.
Much obliged, my Lordships. My Lordships, as the Council stated before that, Section 41 of LARR Act have laid some procedures that the scheduled tribes area should be acquired as a last demonstrative resort, which means if there is no way, only by acquiring this land, the project has been completed, then they should have acquired the land, my Lordships. Even though before acquiring such kind of a land, the state has to get proper prior consent before the Gram Sabhas of the concerned scheduled tribe forest, my Lordships, where the council most humbly submits that the state, after completing 50% of after completing 50% of work, only they applied for the clearance, my Lordships.
Okay. So clearance will clarify with our co-counsel.
Co-counsel, much obliged. My Lordships, if the bench is convinced with the pleadings, may I call upon my co-counsel to proceed with the other two issues?
Yes, thank you.
Much obliged, my Lordships.
Sir, any other clarifications? Yes. Ma'am? Yes, please. Please.
Good afternoon, Honorable Bench. The Council graciously recognizes the presence of your Ladyship. For the convenience of the pleadings, the Council humbly seeks permission to collectively address the bench as Lordships.
Yes.
Much obliged, Lordships. Myself, Speaker 2 for the Appellant Council, will be dealing with issue number 2 and issue number 3. If the bench is well versed with the facts of the case, the Council humbly seeks permission to proceed with the issues.
Yes, proceed.
Much obliged, Lordship. The issue 2 arises in this case whether the said construction of Greenfield Expressway Corridor project without the requisite environmental clearance and later applying for the post facto clearance is justiciable. The Council for Appellant humbly submits that the action for later applying of post facto clearance is non-justiciable, as there is a potential infringement upon the constitutional provisions, various legal doctrines, and also there is a violation in the statutory provisions. First, the definition of post facto clearance is pivotal in this context. So, post facto clearance refers to the retrospective approval sought for an activity which has commenced before the prior approval from the government. The need for post facto clearance itself is a recognition that proper legal procedures were not followed initially, necessitating the retrospective approval process. In this case, the Council would like to quote about environment impact assessment. So, impact assessment is a tool to identify the environmental, social and economical impacts of the project prior to the commencement of the project. The main aim of this impact assessment is to find the adverse effects of this project and also to find the way to reduce these effects before the commencement of the project. But the state has failed to adhere to the to declare the impact assessment in this case. The Council for Appellant humbly submits that in the exercise of the powers conferred to the Union Government under the Environment Protection Act 1986, the Environment Impact Assessment Notification 2006 was issued. So, this notification details the different types of projects that would require mandate prior clearance from the government before commencing the project. Regulation number 2 of this notification provides that mandatory prior clearance is required. The Council humbly submits the notification and also the list before this Honorable Court. Therefore, it is submitted that a new highway project needs to receive prior environmental clearance from the Union Government before commencing the developmental project. Also, the Council would rely upon the case law Rajendra Shankar Sukla and others versus State of Chhattisgarh and others, wherein the validity of the town planning scheme was tested and the same was set aside on account of various illegalities committed by the authorities, including that there was no prior survey or assessment that need for that project. And also, there is a stage called public hearing. This public hearing is a prerequisite and that should precede any step that may be taken under the provisions under the Environment Protection Act.
Yes, Council. Which notification says public hearing is a precondition?
In the notification of, issued by the ministry in the year of 2006, Your Lordships.
2006. What are the various stages of EAA notification, EAA process?
Indeed, Lordship. The Council will answer this question. 2006 amendment made to this notification clearly.
Is it a 2006 notification or is it an amendment?
It is an amendment made to that notification.
When the EAA notification came?
Under the Act, Environment Protection. Under Section 3 of Environment Protection Act, the Environment Impact Assessment notification was issued, and 2006 the amendment was made to this notification, which requires that there are 4 different stages to conduct that impact assessment. That is screening, scoping, public hearing, and also appraisal. So this public hearing is mentioned in this notification, Your Lordship.
Okay. When this particular project was launched for the purpose of acquiring land from the reserved forest, what your co-counsel is claiming, was it before 2006 or after 2006?
After 2006, Your Lordship.
Okay. Then where is the question of post facto hearing? According to you, counsel, from 2006 EA notification demands there should
Indeed,
be a
Lordship.
hearing out of 4 process you have mentioned. Then why you are expecting that the post facto hearing?
We are claiming that they should have conducted prior environmental clearance for this project. So they have failed to obtain that prior environmental clearance before commencing the project and later claiming the post facto clearance, Your Lordships.
I'm afraid of my counsel, because here you have in paragraph 18 wherein it has been said that you have been convinced, you have expressed your consent, and then the land has been acquired, right?
Your Lordship, the project has, the government has introduced this project, and the Shenzhen tribe have initiated mass movements against this project, and the government has pacified them by assuring that their rights will be protected, and so they have agreed to the dislocation from the government.
So you have agreed.
The council would answer that on October 2, 2022, the Ministry of Environment has laid foundation stone for the said project. And after that too, the Shenzhen tribe have lost the faith in the government and also raised concerns against the project, Your Lordship. So it clearly mentions that their rights are violated by the construction of the Greenfield Expressway Corridor project, Your Lordship.
So what are the eventuality factors that made you lose the faith in the acquisition? Because you have already given a consent.
They have not provided the fair rehabilitation centers after the dislocation done by the government to the Shenzhen tribe people, Your Lordship.
Council, our sister judge's clarification is very simple. Whether you made a submission before, whether you haven't consented or you lost the confidence from the government, whatever they promised, it was not given to you. What is your submission? Don't club both.
The council
Because first statement you made, you weren't consulted. As our
because
sister
the government has
judge mentioned it, you were consulted. You made were. Now
Indeed,
you are
Lordship.
saying you lost a belief or faith with the government, therefore you started again.
We have consented because they have pacified that they gave assurance that they will be properly relocated to another place
Okay,
with a
whether
fair
you-
compensation.
Whether the project has to be stalled or you want a remedy.
We have claiming to give the stay order to this project
Why?
because
When-
it is while
when there is a procedural non-compliance, definitely you have a right to ask the project has to be stalled. Now you said you were consulted, you nod your head, yes, you can go ahead because something promised in accordance with the law which is in force. Now you are saying it should be stalled. Why? What is your motive behind it?
Your Lordship, the project we have consulted the council submits that the Shenzhen tribe people have consented to for this project because they believed that they will be properly compensated by the government, but in failure to do so only the Shenzhen have raised concerns against that construction. Beg your pardon, Lordship.
Then you can claim only a compensation. Whatever alternative livelihood is available, you can demand.
The tribes were also in the forest from time immemorial, so it is the native place for them.
Council, we are not at all questioning how long you stay. Your co-council beautifully recorded to us, yes, the place, whatever you habituated, it's from time immemorial.
Indeed, Lordship.
If there is any omission from the government for non-compliance of the AA notifications in the name of hearing or consultation before the land is about to acquire, yes, you nod your head.
The public hearing itself has not conducted in this case prior to
Who's the public here? The concerned public.
The general public, Your
So
Lordship.
who's the general public?
Whether tribal
The
people or
council-
not, whether tribal people or other people.
The other people, because the public consultation should be get from the general public at large. The public hearing procedure is whoever applies for the project, they should submit certain documents to the State Pollution Control Board. On receipt of those documents, the State Pollution Control Board will showcase a notice for public hearing in at least 2 newspapers. So this public hearing will invite some suggestions or objections from the people. Then the government should consider those public consultations from the public before commencing of project. In this case, the government failed to adhere to the process of public hearing. The council submits that before this honorable bench, and rights cannot be compensated by money. So we claim that our fundamental rights is more important than the compensation provided by the government to us.
Council, your co-council beautifully mentioned about that LARERA and Article 31 of Indian Constitution.
Indeed, Lordship.
You people are allowed to get only compensation. Is there any freedom to say the compensation whatever quantified by the government or about to quantify the government is insufficient? Is it a ground for stopping any projects?
We want to stop the construction of this project.
Why?
Because the government policy and this is the, what you call, the development of the nation.
In Lordship, the council seeks that we want to stop the constructions
Why?
as
Just
the proper legal procedure were not,
Because the necessity, the development of the nation, it is very much necessary.
but the development of the nation should not be upgraded at the sacrifice of the poor lives of the people, Your Lordship.
You need only the compensation.
In order to facilitate only, the parliament came out with a law to provide free and fair compensation as and when the state intended to acquire any land for the purpose of public purpose. You beautifully narrated, yes, there are there are procedures. The land has to be identified, it should be notified, people have to be consulted. What
Indeed,
else you
Lordship.
want?
The government can take any part of the land for the purpose of the general public or to the development of the nation, isn't it?
Your Lordship, the council seeks.
The state is a party to different international conventions. You yourself mentioned principles.
Indeed,
Whether
Lordship.
sustainable development is it a duty on the part of a transform or not?
Lordship, there is also a doctrine of public trust which states that government as a trustee has a solemn responsibility to protect and preserve the environment. So, the violation of this doctrine of public trust is evident in the government's decision to proceed with the project without the prior clearance. Also, polluter pay principles also, which was introduced in the year 1972 by the Organization of Economic and Development, it states that the polluter of the environment should bear the cost of damages which has caused by it to the natural environment.
Yes, council is, sorry, please.
But already we recognized the sustainable development as a principle. Okay, there are a lot of decisions, Supreme Court decisions in the country, which recognized the sustainable development is also the law of the land.
Indeed, Lordship.
So in that context, we have to enlighten this bench, because India is also a party of UN Convention on Right to Development.
Indeed, Lordship.
So Narmada Bachavo Andolan 2000, AR 2000
Ended
is a
laws.
landmark case.
The
So till 2000, the right to environment was largely addressed in the country through the court of law. But after 2002, Narmada Bachavo Andolan, the importance they started to give for right to development.
Your Lordship, the Council humbly submits that the Forest Conservation Act 1980, this act mandates the prior environmental clearance. The relevant section is section 2. The Council humbly submits that section.
Council, you are confusing yourself. Whether you are going to substantiate the government failed to comply all the procedural requirements of land acquisition,
Indeed, Lordship.
or the land acquisition is perfect, or interests were not considered. Where you are going to stand?
The land acquisition is not done in a proper way, Your Lordship. They are not adherence to the procedure established by law. That is,
Please list what all the procedures you are expecting to be complied as and when the state intended to acquire a land.
they have to, before implementing this project itself, they should conduct the public hearing and also
Was it
they should,
conducted?
Was it conducted?
In this case, was it conducted?
indeed not, Your Lordship. They have failed to adherence to the public hearing process. The moot proposition is also silent about that, Your Lordship.
Yes. So next clarification you said, mention about our brother judge also clarified polluter pay principle. Which international instrument expects the polluter has to repay? Is there any section? Is there any article?
The Council would like to submit a precedent that Vellore Citizens Welfare Forum versus Union of India, the court interpreted the principle of polluter pay, that polluter has absolute liability not only to compensate the victims for the hurt caused due to them.
Referring what instrument the court made that observation? Because we the constitutional bench, we can't go only with the law.
Ended, Lordship.
What is the law?
Your Lordship, there is a legal maxim that cessante ratione legis, cessant ipsa lex, which means the reason for the law ceases, then the law itself
Okay,
ceases.
legal maxim, is it a primary source or secondary source? Because you are a student of interpretation of statutes, we have internal aids and external aids.
The Council humbly submits that the, every laws are enacted with a specific purpose, so that laws also.
Where is the law? Every laws are made with a specific purpose. Where is the law? To
Environment-
ensure compensation to you people as a victim of because of pollution.
The general public.
Lordship, under Article 141, it creates that Supreme Court judgment can be taken as a precedence before this honorable bench. So we have submitted that
According
case.
to you, Council, Supreme Court judgment will bind the Supreme Court. You read
And
one
it's a party aggrieved by the award given by the National Green Tribunal can approach the honorable Supreme Court for further claims.
So you have approached for what? Under which article you have approached the National Green Tribunal? Sorry, under which section you have approached the National Green Tribunal?
As I said earlier, section 22 of that said act, Your Lord.
So to allow you to exhaust the jurisdiction of appeal.
Indeed, Lordship. We have appealed before this honorable court under Article 136, which states that subordinate courts also includes tribunals.
Now are you an applicant or appellant?
In the appellant, Your Lordships.
Okay, proceed.
You are the aggrieved party. You are the
Indeed,
aggrieved
Your
party.
Lordship. The Council seeks permission to proceed with issue number 3.
Yes, yes, yeah, good, please.
So whether the construction of Greenfield Expressway Corridor project is in violation of coastal regulations or notification and later on claiming exemption under post facto clearance is valid. The Council humbly submits that there is no violation in the coastal regulations or notification and later on claiming exemption under post facto clearance is invalid. It's a deadly assumption that humans are separate from the environment. That is the actual root of this current problem. If the development of the two had been considered in the equal footing, then it would have led to true sustainability here. Then CR is a notification. Under Section 3 of Environment Protection Act of Bharadam, the coastal regulations on notification was issued in the year of 1991 for the first time for the regulation of coastal activities. So as per this notification, the coastal land up to 500 meter above the high tidal zone and the stages of 100 meter along the banks of rivers, estuaries, backwaters which are subject to tidal fluctuations are known as coastal regulation zones. And here, as I said, 2006 notification has decentralized the projects as category A and category B. Category A projects requires mandate prior clearance from the government, whereas category B is further divided into category B1 and B2. Here, B1 requires the mandate clearance, B2 doesn't require mandate clearance. The council humbly submits that this said construction of Greenfield Expressway Corridor project comes under the purview of category A. Here it mentioned that projects such as mining, thermal power plants, river valley infrastructure, which includes roads, highways, ports and harbors. These all are included in category A. So the council submits that the highway project must priorly obtain the prior clearance before this construction of this project. And also, the council submits a case before this honorable bench that Kerala State Coastal Zone Management Authority versus Marudu Municipality, the Supreme Court ordered the demolition of illegal structures, highlighting the importance of stringent enforcement of CRZ regulations. That Panchayat have issued permission to the buildings in violation of relevant statutory provisions. So the permission granted by Panchayat was illegal and void. No such development activity could have taken place. So in view of that findings, the directions were issued to remove all the structures. And so also in the case of Sanju Panda versus state also, unauthorized constructions was directed to be demolished. And there is also a famous principle known as precautionary principle. So it is the principle which states that it is better to err in the support of care and protection than in the council humbly seeks permission. Care and protection in the opposite direction, where any harm caused to the environment may be impossible to be reversed. As the saying always goes, prevention is always better than cure.
Which section of which act speaks about precautionary principle, council? Is there any law for precautionary principle? Which law, which section says?
Beg your pardon, the council is unaware of the section. It is a legal principle which is to be considered.
Who founded? It's a council you yourself founded. Who founded a precautionary principle?
It is the state's obligation to consider this precaution.
Which law says?
Beg your pardon, Lordship, the council
You
is
are in a constitutional bench, council. When you make all statement, you yourself claiming how we will. Whether this bench is have an authority to decide only procedure laws or substantial question of law?
It is a procedural law.
Yes, please continue, council.
The decision to grant the post facto clearance is contrary to the logic of this precautionary principle. The underlying factor of this principle is that environment harm is often irreparable and it is wiser to avoid any damage.
Council, you can skip because you yourself said there is no law. Then why we have to discuss all? When there is a law, definitely we are ready to hear.
The council humbly submits that section 3, which was mentioned in environment impact assessment, which is considered as precautionary measures, Your Lordship. If the bench is convinced with the arguments, the council seeks permission to call her co-counsel to proceed with the prayer, Your Lordship.
Co-counsel to?
Proceed with the prayer.
Prayer submission.
Okay, please.
Please go ahead.
Much obliged, Lordship.
Please, John.
My lordships, wherefore in the lights of issues raised, arguments advanced, authorities cited, the counsel for appellant hereby humbly prays to adjudge that the appeal petition filed by the Democrat, an NGO, and Ms. Varshi, a law student, is maintainable and prima facie valid, and to declare that the acquisition of land from the Senjan tribe for the said project is in their violation of fundamental rights, and the acquisition of land from the Senjan tribe is in the violation of their fundamental rights, and the construction of the said project is in the violation of CRZ notifications and applying for the post facto clearance is unlawful and unjustifiable, and are to pass any such orders which this honorable court may deem fit and proper in the lights of justice, equity and good conscience, my lordships. My lordships, the council most humbly requests the honorable bench to consider the life of Senjan tribes, as they have full faith in this honorable court that this honorable court may not leave them, and their life relies upon the judgment which will be given by this honorable court. Much obliged, my lordships.
Thank you.
Am I audible, my lordships? May I please the court, the council seeks permission to address the bench collectively as your lordships. Much obliged, your lordships. My lordship, since my learned counsel has omitted certain material facts, the council seeks permission to begin with the facts of the case in short, my lordship. Much obliged, my lordship. My lordship, Bharadam is a South Asian country with having Tamil Nadu as a southern state. So in Tamil Nadu, there are two important eminent cities, which is Silvester and Puhar, my lordship. So the Union Government of Bharadam has proposed the Greenfield Expressway Corridor project to connect the two eminent cities, that is Silvester with Puhar, my lordship. My lordship, this 263 highway kilometer project has reduces the long 8 hours travel from 3 hours to these two eminent cities, my lordship. My lordship, the government has identified this project as an exemplary project with inculcation of enhanced connectivity to economic centers, multimodal logistic parks and etc. My lordship. My lordship, this 263 kilometer highway project passes through various lands, which includes 45 kilometers through Edukal Reserve Forest and 55 kilometers through coastal regions, which includes villages namely Kodi, Kadai and Kadambu, my lordship. My lordship, upon learning this, Shengan tribes, being the native regions of Edukal region, have made concerns and objections regarding this, and Democrat has filed a petition regarding violation of fundamental rights, my lordship. My lordship, however, this petition was dismissed by the High Court, and dealing this, the petition council has appealed before the Supreme Court, my lordship. My lordship, upon completion of 50% of the work, the government has applied for post facto clearance.
Council, you are an appellant or you are a petitioner?
Indeed, my lordship, we are in behalf of the respondent, my lordship.
Sorry, respondent?
On behalf of the respondent, my lordship. Okay, indeed, my lordship. May I proceed, my lordship?
Yes, proceed.
Indeed, my lordship. My lordship, so following the notification from Ministry of Environment, the government has applied for post facto clearance, my lordship. So on knowing this, Varshi has filed a petition before the NGT for the dismissal of, lacking of environment clearance and CRZ clearance, my lordship. However, that petition was also dismissed by the NGT, so therefore Varshi has filed a petition before this Honorable Supreme Court, my lordship. So the Supreme Court has clubbed the petition for final hearings, my lordship. So if the lordships are convinced with the facts of the case, the council seeks permission to proceed with the issues, my lordship. Indeed, my lordship. My lordship, this present case involves 3 issues. The first issue is regarding violation of fundamental rights of the Shengan tribes due to the proposed project, and second issue deals about the environment clearance and post facto clearance regarding EIA notification, and third issue deals about the CRZ clearance under CRZ notification, my lordship. If your lordship permits, the council will advance arguments of issue number 1, my lordship. My lordship, it is to mention that Council 1 will be dealing issue number 1, and the council will not take more than 18 minutes. Council 2 will be dealing about issue number 2 and 3, and he will not take more than 22 minutes, my lordship. Indeed, much obliged, your lordship. My lordship, issue number 1 is that whether the acquisition of land of the tribal peoples under the for the said project and construction of highways through Edukal region is in violation of the fundamental rights of the Shengan tribes. My lordship, it is humbly submitted before this Honorable Supreme Court of Bharadam is that the acquisition of land for the said project for the public interest cannot be said as the violation of fundamental rights for the Shengan tribes, my lordship. My lordship, it is to be noted that the nation's thriving economy relies on this highways, my lordship. So as per facts, the nation's economy has been increased with the inculcation of robust infrastructures, which includes the highways, IT sectors and etc., my lordship. My lordship, this Greenfield Expressway Corridor project reduces long 8 hours to 3 hours, my lordship. So the primary purpose of the proposed highway corridor project is not only to link the eminent cities Silvester and Puhar, which leads to the increase of trade and tourism, my lordship. My Lordship, it is a known fact that Sylvester being capital, it is said to be the Detroit of Bharadam, and connecting these two cities not only reduces the hours from 3 hours to 8 hours to 3 hours, but also increases trade, tourism, as Sylvester is known to be the religious hub, and it is said to be a cultural hub of the state, my Lordship. My Lordship, for your bench's convenience, the council would like to split up this issue into two parts, my Lordship. So the first part will be dealing about the procedures under the various acts which must be followed by the government, and second part will be dealing about the justification for non-violation of fundamental rights, my Lordship. Indeed, my Lordship. My Lordship, heading towards first part, my Lordship. My Lordship, according to section 2 class 1 of the Law Act, which clearly permits the government to acquire the land, my Lordship. So according to this act, when the appropriate government is the appropriate government can acquire land in case of public purpose for the construction of highways, my Lordship. So this was also explained, my Lordship. The council seeks permission to submit the compendium, my Lordship. Indeed, my Lordship. Indeed, my Lordship. A policy is mentioned in the compendium, my Lordship. So, indeed, my Lordship. My Lordship, the government has entered in. Please refer flag number 16, my Lordship. Indeed, my Lordship. So in that policy, for infrastructure projects, which includes all activities and items under the notification of Department of Economic Affairs, clearly provides highways as a permissible activity as an infrastructure development, my Lordship. So under this policy, government has complete power to acquire the land for the purpose of said construction, my Lordship. My Lordship, it is to be noted that the Land Acquisition Act has been upheld by the Constitution as a valid provision, my Lordship. So this was exemplified in the cases of Kesavanandi Bharati, the state of Kerala, where the Supreme Court upheld the government's ability to acquire land for the public purpose from anyone, my Lordship. My Lordship, this was also clearly said in the case of UP Awas Evam Vikas Parishad with Ram Singh and others, which clearly reiterates that land acquisition is permitted in public interest, subjected to certain constitutional rights, my Lordship. My Lordship, therefore, it clearly provides that government is enabled to acquire land under Law Act, my Lordship. My Lordship, therefore, the government is not.
Yes,
Indeed, my Lordship.
You said land acquisition permissible subject to
Certain constitutional rights, my Lordship.
rights.
Indeed,
So
my
here
Lordship.
the the submission which was made by the petitioners or applicants were
Indeed, my
their
Lordship.
fundamental freedom to settle and reside
Indeed, my Lordship.
is violated.
Indeed,
So
my Lordship.
what attempt you have in order to save their life? Because
Indeed,
as
my
per the
Lordship.
fact, they lived from time immemorial.
Indeed, my Lordship.
They are the
So,
full dependent of the resources what you are acquiring.
indeed, my Lordship.
Yes.
It is covered under the second part, my Lordship. So I will give a clarity
it is
about
a
that.
tribal rights, indigenous population. They have a cultural identity.
Indeed, yes, my
You are
Lordship.
saying that you are going to form a cultural hub, but not at the cost of destruction of cultural identities.
Indeed, yes, my Lordship. The
You are
count.
going to promote a tourism in order to sacrifice the indigenous people and their livelihood.
Indeed, no, my Lordship. Not just tourism. This
Indeed
highway
or no,
project.
you are clubbing both. Indeed, no lordship.
In-
Is it indeed lordship or no lordship?
My Lordship, I am addressing that the question is not. My Lordship, this project not only boosts tourism, my Lordship, it results in heavy infrastructural development, my Lordship. So this,
So what? So infrastructure you can do any place.
indeed, my Lordship.
After
Indeed, my Lordship.
making a law and making a procedures,
Indeed, my Lordship.
you attempted to make in a place where their livelihood is in danger.
My Lordship, right to livelihood is enshrined under Article 21 of the Constitution, my Lordship. But it is also to be noted that right to development has also been included in the Article 21, my Lordship.
Which article? Which line says
Indeed,
right to
my lordship.
development is a fundamental right?
Indeed, my Lordship. The Council seeks time, my Lordship. 2 minutes.
What's restricted to obtain the prior permission to commence the project?
My Lordship, pardon, my Lordship.
What's the restricted to obtain the prior permission to commence the project?
Indeed, my Lordship. Prior permissions are not applied.
Why after completion of the 50% only you are obtaining the
Indeed, yes.
What was the restriction to obtain the prior permission to commence the project?
Indeed, my Lordship. We have applied for post facto clearance, which will be dealt in issue 2 and 3 by the co-council, my Lordship.
What was the restriction to obtain the prior permission to commence
My Lordship, there was a large protest in the Schengen tribes villages, which we was in the process of pacifying them, and also we were handling the pandemic situation in 2020 to 21. So that made and this project was also made with the funding agency of JASCA, my Lordship. We do have no funds regarding this. So this is a 15,000 crore project, which is an enormous amount, my Lordship. So under these processes, clearance was not applied, and we have we have notification from Ministry of Environment, and under that we have applied for post facto clearance. So this will be held by my co-counsel in issue 2 and 3, my Lordship.
So please justify which article speaks right to development is a fundamental
Indeed, my Lordship. I'll answer, my Lordship. My Lordship, under case G. Sundar Rajan, indeed. My Lordship, apologies, my Lordship. My Lordship, under the case of A. Kuru Prasad Rao, State of Karnataka, equivalent citation is 2013 RACW 5087, which clearly provides, and also in the case of Shanti Star Builders vs. Narayana Kimlal Totem, it clearly provides right to development is in the ambit of Article 21, my Lordship. So equivalent to right to livelihood, right to development is also in ambit of Article 21, my Lordship.
Is,
and
it,
also
is it a constitutional bench decision?
Indeed, my Lordship, the council
Is it a decision given by the constitutional bench?
Indeed, my Lordship, it was before the Supreme Court, my Lordship.
But on the other hand, Ratlam Municipality, Vellore Citizen Forum,
Indeed, yes, my
they
Lordship.
recognized polluter pay principle, precautionary principle, public trust doctrine,
Indeed, my
are
Lordship.
treated to be law of the land.
Indeed, my Lordship. Even though public trust doctrine is present, there is an equivalent doctrine, which is the doctrine of eminent domain, which provides the government to acquire property for the public interest, my Lordship. So we, after providing rehabilitation and compensation, we have the power to acquire the lands of tribes, my Lordship. So this provides the equivalent power to the government to acquire the lands, my Lordship. So the council will answer the fundamental rights violation in second part, my Lordship. My Lordship, may I proceed with the arguments? Much obliged, my Lordship. My Lordship, not only under the Law Act 2013, the government has also power under National Highways Act 1956, my Lordship. So under section 3 class A, when the central government has for the public purpose, any land can be acquired for the construction of highways, my Lordship. Here, for the national interest and public interest, the government has acquired the land under National Highways Act, my Lordship. This was also explained in the case Union of India v. Shivaraj, where the Honorable Supreme Court exemplified the government's authority under this Act, my Lordship.
Council, the bench requires a clarification.
Indeed,
it's
my
not
Lordship.
recording whether you have a power to acquire a land or not.
Indeed, my Lordship. Indeed, my Lordship.
When you intended to acquire a land, whatever projects you have mentioned
Indeed, my Lordship.
is in accordance with the procedure established by law.
Indeed.
Whether any fundamental rights or fundamental freedom of any people in India is violated or not.
Indeed, my Lordship.
Here the contentions or submission which was made by the applicant and petitioner were their fundamental freedom to settle, their fundamental freedom to occupation, their cultural freedom is absolutely disturbed.
Indeed, my Lordship. Since our petitioner council has quoted Law Act in their arguments, so the council is obliged to say that we have power under Law Act.
No, don't, you as a state don't simply get a reference from them.
Indeed, my Lordship.
They are claiming their life is in danger. Why you are taking a reference from them?
Indeed, my Lordship.
Have you complied all the procedural requirements in the legislations which you parliament made?
Indeed, yes, my Lordship. We have made every legislation under this argument, and we have specified the tribes that their interest will be provided, my Lordship. So the council will be handling fundamental rights.
Their interest will be provided.
Protected, my Lordship. Apologies, my Lordship. Interest will be protected, my Lordship.
Okay.
Apologies.
So in the process of protection, have you strictly complied as our brother judge happily asked?
Indeed, my Lordship.
Which made you to not to make a decision what the LARA expects?
My Lordship, can you repeat the
Acquisition
question, my
and
Lordship?
Rehabilitation Act expects.
My Lordship, rehabilitation will be provided, my Lordship. We do have concern on the tribal peoples. We are planning to rehabilitate them near the highways and in the same medical region, my Lordship. So this highways not only promotes public interest, it also provides interest to the tribal peoples, my Lordship.
How they will do all their habitual occupation like?
Indeed, my Lordship.
What they will do in a highway? They don't know how to dress.
Indeed, my Lordship. My Lordship, please refer facts. As per facts,
Which page of compromise?
Indeed, my Lordship. My Lordship, please refer 8th paragraph of the facts, my Lordship. My Lordship, it is clearly stated that Schengen tribes, who are the natives of Idukal region, my Lordship, so they are not the lordship.
Fantastic.
Indeed.
That's what you are claiming.
Indeed, yes, my lordship. We are not saying that they do not have rights, my lordship. We are saying that we do have rights for the acquisition purpose, and we are going to rehabilitate the near the highways and into the region, my lordship. So this clearly says that the right to livelihood is not violated here, my lordship. May I proceed, my lordship? Indeed, much obliged, my lordship. My lordship, that was the summary the first part of submission, and now I will be addressing the second part, fundamental rights. So, since my co-counsel has stated we have violated 19 and 21, the council would like to make two-step argument regarding this issue, my lordship. First will be about Article 19 and second will be about Article 21, my lordship. My lordship, according to Article 91 class E, every citizen has the right to reside, my lordship, but it has certain restrictions under 19 class 5, my lordship. So, the rights of private people to reside and settle in the ethical reserve forest cannot be said as absolute rights under 19 class 5, my lordship. So this was also clearly said in n number of cases, which includes currents in the state of UP, courts on its own motion, the Union of India, and much more. So this clearly proves that currency. My lordship, here right to move is not an absolute right and is subject to certain restrictions under 19 class 5. My lordship. I proceed, my lordship.
They are happy that the petitioner and appellate counsel happily record public trust. You as the state simply ignore what is the duty you have to preserve.
Indeed, yes, my lordship. My lordship, we are not providing. The fundamental rights are not violated, my lordship. According to doctrine of public trust, we should protect their trust, my lordship. So, as already mentioned, this highway project is in assistance with JASTA agency, my lordship. So, even
Instead of ensuring why you attempted again, maybe a clarification for your co-counsel still, why you were attempted not to make a consultation before going to launch the projects.
Indeed, my lordship. We have specified this.
Since the statement you made, you attracted more foreign direct investment, then you want to flourish yourself. Therefore, first you attempted to launch a project that you thought you can consult with them.
Indeed, no, my lordship. We are not attracting the investments, my lordship.
Since it was a pandemic, we thought we are receiving 15 so and so crore rupees, that's what they want to stop.
You have to refer to paragraph 7 also, whether you have stated that.
Indeed.
Refer to paragraph 7.
My lordship, we are in assistance in the JASTA funding agency, my lordship. My lordship, this project involves 15,000 crores, my lordship. So, for improving the public interest, so we have enabled multi-modal logistic paths connected to economic centers, which leads the public interest is safeguarded here, my lordship.
Which constitutional article expects you to make all development projects?
My lordship, under the DPSP, Director Principle of State Policy, which provides social economic justice should be protected and development projects should be enhanced, my lordship. So, under Article 31 class C, the land commission also has provision for its validity.
But there is a conflict between part 3 and part 4.
Indeed, my lordship. That's a document.
Part 3 or part 4?
Indeed, my lordship. According to doctrine of harmonious construction, both these DPSP and fundamental rights should be balanced, my lordship. And if there is a conflict between DPSP and fundamental rights, then DPSP should be given priority, my lordship. But here, fundamental rights are not violated here, my lordship. DPSP should prevail since fundamental.
Council, be clear. You said the fundamental rights of the tribal is violated.
Indeed.
You are very much interested to compensate. That's a statement you made just 3 to 4 minutes back.
Indeed, no, my lordship. We are
Then
not.
why you have to compensate? Why you have to rehabilitate?
My lordship, we have acquired their lands, my lordship. So we are, according to Law Act and National Highways Act, we should compensate. My lordship, the council seeks permission.
Please continue.
Indeed, much obliged, my lordship.
Which law says you have to compensate?
Indeed, my lordship. My lordship, according to National Highways Act, 3 class H and 3 class G and H provides the compensation process, my lordship. And also according to section 25, which provides.
Does compensation includes rehabilitation?
Indeed, my lordship. Rehabilitation was said in the National Resettlement and Rehabilitation Policy, which was presented in 2007 by the government, my lordship. So, complying on that, rehabilitation must be provided, my lordship, and we are planning them to provide as soon as possible, my
Whether
lordship.
policy is it a law?
Indeed, yes, my lordship. Public documents
where it
can.
says? Which law, which section, which article says policy is a law?
Lordship, the council pleads ignorance, but the public documents can be admitted under section 74 of the Evidence Act, my lordship. So thus we can admit that.
Section?
65, sir. Indeed, apologies, my lordship.
Whether 65 of Indian Evidence Act is relevant to the constitutional bench?
Indeed, yes, my lordship. The council pleads, sorry. Apologies, my lordship. The council here is to provide reference for that since public documents is admissible here, my lordship. So under Evidence Act 64, the public documents is admissible. Therefore, policies can be taken into account, my lordship.
What is the difference between public documents and policy?
Indeed, my lordship, policies are said to be the public documents, and it is a signatory of government, and thus this can be admissible in the bench, my lordship.
Okay, according to our Bharadam constitution, what is the definition of law council?
Indeed, my lordship.
Do you have a definition for law in Bharadam?
My lordship, Bharadam has obtained its independence by
I
1947.
am not asking when you got an independence.
Indeed,
is
my
there
lordship.
any definition of law to Bharadam?
My
In
lordship,
the law or in a constitution?
The constitution is embodying socialist, secular, democratic, republic nature of polity, my
Preamble,
lordship.
we don't want.
Indeed, my
Is
lordship.
there any definition of law in Bharadam's constitution?
Lordship, the council pleads ignorance.
Yes,
my
please
lordship.
continue.
Much obliged, your lordship. My lordship, the council is pleased to answer, my lordship. Article 13 provides the definition of law, my lordship.
Law means and includes?
Much obliged. The council seeks permission, my lordship. My lordship, all laws definition in this part, unless the context otherwise requires, the state in...
Please, 13.3 you read, don't 1 and 3.
Indeed, my lordship. Law includes any ordinance, order, bylaw, rule, regulation, notification, custom or usage having in the territory of India the force of law, my lordship.
Where is your political document, policy?
My lordship, notification... Lordship, the council pleads ignorance, my lordship. The council is unaware of that. Much obliged, my lordship. Lordship, as already stated, right to reside is not an absolute right, and it is under certain restrictions.
As already submitted.
Indeed.
Don't state. You are representing
Apologies, my lord. Apologies, my lordship. As already submitted, Article 91 Class C cannot be set as an absolute right, and thus, since it has certain reasonable restrictions under 19 Class 5, the right to reside has not been violated by the government, my lordship. My lordship, next 21.
What about the right to occupation? What they asked from 19 subclass 6?
Indeed, yes, my lordship. Rehabilitation includes providing equivalent land which they were having.
Now
And
again you said rehabilitation is not a part of your National Highways Act.
my lordship, pardon, my lordship.
Rehabilitation is it a part of your right to compensation under the National Highways Act?
Indeed,
That's what
indeed.
you submitted.
Indeed, my lordship, not under National Highways Act, under Land Acquisition Act, rehabilitation should be provided, my lordship. So therefore, we are planning to provide in the same medical region which does not affect their occupation, my lordship. And also, we are providing equivalent lands which they own, so thus not violating occupation, my lordship. May I proceed, my lordship?
Where you conferred a right to property as a land council. Why
Lord-
you made a statement even you are ready to provide equivalent land?
My lordship, under rehabilitation process, we should provide the land equivalent.
You read which section of your the LARE Act says?
My lordship, LAR says that rehabilitation should be provided. It does not say equivalent land, my lordship.
Then why did you
Lordship,
present?
in concern of tribal peoples, we are providing equivalent lands, my lordship. We do have concern on tribal people, so
Are they owner of the forest land?
indeed,
Are they
no.
owner of the forest land?
Indeed, my lordship, according to Forest Rights Act, under section 3, it provides certain rights, which provides right to ownership and right to use the resources for the occupation, my lordship.
Not asking are they allowed to use the resources?
Indeed, my
Are
lordship.
they owner of the land?
My lordship, it provides right to ownership also, my lordship. Under 3 class A, it provides right to ownership, my lordship. Indeed, my lordship. Much obliged, my lordship. So next part regarding Article 21, my lordship. So it is humbly submitted that Article 21, yes, indeed, yes, it includes right to livelihood, but as already stated, development is also included in the ambit of Article 21, my lordship. So regarding DPSP and fundamental rights, as already stated, DPSP should be provided, and thus in the public interest, the government has laid Greenfield Expressway Corridor project, my lordship. My lordship, it is humbly submitted that according to Narmada Bachao Andolan West Union of India, the Honorable Supreme Court held that displacement of tribal people for the development projects cannot be said violation of fundamental rights unless the rehabilitation is provided, my lordship. Here, so while relying on this case, the displacement of tribal people for the said project cannot be said as violation of fundamental right. That is Article 21, my lordship. My lordship, also in the case of State of Kerala West People Union for Civil Liberties, it clearly says that eviction of tribal people from their land cannot be considered as violative of 21, my lordship. My lordship, therefore, if we permit the tribal people to stay here, then no...
Then why
Apologies, my lordship.
Then why you volunteer to pay money and provide a land?
Indeed, my lordship. It is under RAR Act, so we too, as already stated, we have concern on the tribal peoples, and we have recognized their rights under constitution. And since we are acquiring the property of their region, we are providing rehabilitation and compensation, my lordship. So under RAR Act, we are acquiring their lands, my lordship. Indeed, may I proceed? Much obliged, my lordship. My lordship, therefore, acquisition of land from the tribal peoples cannot be said as Article 21, and then if this land has been not acquired, then no land can be acquired for the development project, my lordship. So therefore, this humbly submits that the acquisition of land by the government for the said project cannot be said as violation of fundamental rights, since it promotes DPSP and national interest, my lordship. So if your lordships are convinced with issue 1, my co-counsel will take over issue 2 and 3, my lordship. It's a pleasure arguing before this bench, my lordship. Much obliged.
It's warm greeting to you. Argue before this. Warm greetings to the honorable bench. I am the counsel of the respondent. The counsel seeks permission to advance the arguments of second and third issue, your lordships. Highly obliged to your lordship. The second issue is whether the said construction of Greenfield Expressway Corridor project without request to environmental clearance and later applying for the post facto clearance is justiciable or not.
Respond to my brother judge, then you continue.
Indeed, your lordships.
Because your co-counsel said you are going to respond.
Indeed, your lordships.
Prevent you not to get any clearance.
Indeed, yes,
before
your lordship.
launching the project. You respond, then continue.
Indeed, yes, your lordships. Your lordship, we have 3 reasons for that. The first reason is we have the public necessity and public necessary in that project, and it was a funding project by the JASCA agency, your lordship. Because so we get assistance from another company, so we have to do that project very earlier, your lordship. And we have faced a lot of problems both in law and order as well as the judicial proceedings, your lordships. In before commencement of the project, we have faced a mass protest from the Shengan tribes, and after the commencement of the project, there is judicial proceedings which have been started by the Democrat NGO regarding the fundamental rights of the Shengan tribes in the Honorable High Court, your lordship. Thus, these problems have been forced us to apply for the post facto clearance, your lordship. May I proceed, your lordships?
Yes, counsel. So according to your submission, whenever there is agitation, you will simply ignore whatever law you made.
Indeed, no.
You presented 3 aspects. Public necessity, since you got the money from them, then judiciary is repeatedly watching you. Therefore, you don't want to consult with the people. Is it a license for you to violate all fundamental rights and freedom, counsel?
Indeed, no, your lordships.
That's what
We
you
are not.
presented.
Indeed, no, your lordships. We are not violated any fundamental rights. In here, we only not applied for the prior environmental clearance.
Why?
And
Is it
your
a
lordship,
license for you to violate the law which you made to protect the people or protect the constitutional goals?
Indeed, your lordships. Your lordships, the council seeks permission to submit this document before this court. Your lordships, may I proceed, your lordships? Your lordships.
Please respond and proceed.
Your lordships, under section 3 of the Environmental Protection Act 1986, we have the power to enact any legislation or notification for protecting and improving the environment as well as to comply with the economic practices, your lordship. In the case of Yeser Oil Limited versus Halar Uttarakhand Samiti and others, the Honorable Supreme Court held that there need not necessarily be a deadlock between development on the one hand and the environment on the other. The objectives of all laws on environment should be create harmony between the two, since neither one can be sacrificed at the other of the other
Very good.
worships.
You made very beautiful observation from SR Oil. Have you made the same balancing in this particular case?
Your Lordships, by this, we have created a notification which is submitted before this course, Your Lordship. In this notification, this office memorandum giving a chance to the persons who are not obtained the prior environmental clearance for applying for the post facto clearance, Your Lordship. As this was published in the January 28, 2022, Your Lordship. By this notification, we have applied for the post facto environmental clearance on 28 September, apologies for the date, Your Lordship, September 2023, Your Lordship. As we have complied with the laws of the law of the land, Your Lordship.
Yes, Council, your intention was very clear. As your co-counsel beautifully submitted a compendium, you have a list of activities. You have every freedom to acquire a land.
Indeed, Your Lordship.
When you intended to acquire, why you waited from 2022 to 2023?
Your Lordships, the council.
2022 and to 2023. Why you have waited?
Your Lordships,
to consult the people.
Your Lordship, please repeat the question, Your Lordships.
You as a state have a freedom to acquire a land for any purposes.
Indeed, Your Lordship.
The same government made a law as and when you are going to do a developmental projects, you have a need to consult with the people.
Indeed, yes,
right?
Your Lordship. Indeed, yes, Your Lordship.
Then you, ignoring the same, why you started in 2023?
Your Lordships, we have started the project in...
No, post-decisional hearing I am asking. I didn't ask a
No,
project
the
when you
question is very
attempted.
clear, my counsel. Here we are asking you, before you could commence your project, okay? There is a requisite that you have to have a hearing. And there is a lapse of time. So
Your
how do you
Lordship-
convince this bench, there is a delay in adopting the procedure?
Your Lordships, in January 2023, the NGO has filed a petition before the High Court, Your Lordships. Thus, we have a judicial proceedings among this secondary violation of fundamental rights, Your Lordships. And as per the fact sheet number 8, the government has specified the tribes. Thus, we have obtained the consents from them, and thus we have commenced the project, Your Lordships. After that, the judicial proceedings have been started by the NGOs, and all the laws cannot be enforced. We have to protect the law and order from those places, Your Lordship. Thus, we have lot of obligations on that. Thus, we cannot apply for the pre-environmental clearance, Your Lordship. And thus, we have applied for the post-facto clearance as soon as we can get a chance to do that, Your Lordship.
Council, you read a compromise, paragraph number 6. The state is more dependent of agricultural dependent and third longest coastline, and there is a report which is indicated 73 species of the plant that are endemic in the same zone.
Indeed, yes, Your Lordship.
After knowing all the data, you are very particular to acquire the same land without consulting the people.
Indeed, no, Your Lordships. This Sengan tribes, the facts is not mentioned that the Sengan tribes are doing agriculture, Your Lordships. They are selling the minor products of the forests only, Your Lordships. According to the fact sheet number 8 of the...
No, I am not saying Sengan people are doing agriculture.
Indeed, Your Lordship. Indeed, Your Lordship.
Please read paragraph number 6 and second line.
Indeed, Your
The
Lordship.
southern part is more agriculture dependent and scattered industrial development. The next two lines says third longest coastline. The last line of the same paragraph says 73 species of plant that are endemic to the same stretches.
Indeed, yes, Your Lordships. It was an agricultural land, it was an environmental thing, as we have following a Greenfield Expressway Corridor project, Your Lordship.
It was an agriculture, not it is an agriculture.
Indeed, Your Lordships. And Your Lordships, we have following this project.
Where is the choice for you to convert the tribal land for non-forest purposes? Is there any license to you?
Your Lordships, the government can do activities under the Indian Forest Act 1927, which have been mentioned in our compendium flag number 13, Your Lordships. The council pleads the honorable Lordships to refer flag number 13 of our compendium, Your Lordships.
Proceed.
Indeed, Your Lordships. Your Lordships, in that section, in that Forest Act, section 26 states about the prohibited activities of that forest, Your Lordships. In that, the construction of roads is not an activity which was an prohibited activity, Your Lordship. And we have some problems to recure approval for that, Your Lordship. And thus, we have apply for that post-facto environmental clearance as soon as we have the chance, Your Lordship.
Council, our clarification is very simple. We are not clarifying whether activities you carried is lawful or unlawful, prohibited or permitted.
Indeed, Your Lordship.
You as a state have every freedom to acquire a land as and when you have a need in the name of a public purpose.
Indeed, Your Lordship.
What are the preconditions? You have to consult with the people whose rights are going to be affected.
Indeed, Your Lordship.
Have you complied with the same procedures or not?
Indeed, Your
If
Lordship.
you say you can't, you haven't, what are the reasons for that?
Your Lordships, we have gained the consent from that tribal people, Your Lordship. In the fax number.
Is it
8.
a pre-decisional or post-decisional?
Your Lordships, it is a pre-decisional consent, Your Lordship. In the fact sheet number paragraph 8, it was mentioned that the government specified the tribes and assuring that their interest in the forest will be protected and secured before commencement of the project. Your Lordships, thus we have specified those tribes and we are commenced the proceedings to save the interests of the tribes also, Your Lordship. As it was in a process of law, Your Lordship. It was in a process, Your Lordships. And we have a time period of 2 years to give a compensation and as well as a rehabilitation, Your Lordships.
Continue.
I oblige you to Your Lordships. And Your Lordships, I have to argue before this bench regarding the second issue under the 2 grounds, Your Lordships. The first ground is post facto environmental clearance is permissible under the Environmental Protection Act 1986, Your Lordship. And the second.
Can skip because already you did a pre-decisional hearing. Then why you want to expand post-decisional discussion here?
Your Lordships, the council, if the court is convinced with the second issue, the council
No, you made a submission. You did a pre-decisional.
Your Lordships, we have taken a pre-decisional hearing for the land acquisition, Your Lordship. For this project,
The whole project, it's the whole case itself a land acquisition. Then what else you have?
Your Lordship, for the land acquisition is an.
No, here symbol, that issue which is presenting, whether you state have consulted the people as and when you intended to acquire. You made a submission just 2 minutes back. You did a pre-decisional hearing. Then what's the need of discussion of post-decisional issues here?
Your Lordships, we have stated that the Sengan tribes have been specified, Your Lordships. And for the people, general public, we will held a post-decisional hearing, Your Lordships. It was permitted by the Supreme Court in the case of Electrodam Limited versus Patel Vipul Kumar Ramji Boy, Your Lordship. In that, the court clearly held that we deem it appropriate to change the nature of requirement of public consultation or public hearing from pre-decisional to post-decisional, Your Lordship. Thus, the court, with this judgment, we are.
Yes, counsel, you leave alone a decisional hearing. The petitioner and applicant categorically claimed precautionary principle.
Indeed, yes, Your Lordships. Your Lordships, as per the government, the project name is Greenfield Expressway Corridor Project, and we are following a Green Highway Policy 2015 among this project, Your Lordship. For the convenience of this bench, the council pleads to refer the flag number 9 of our compendium, Your Lordship. Indeed, yes, Your Lordship. In that this highway policy, the vision to develop eco-friendly national highways with participation of the community, farmers, NGOs, private sectors, institutions, government agencies, and the forest department for economic growth and development in a sustainable manner, Your Lordship. Thus, our construction of highways is compliant with this highway policy, Your Lordship. This policy have 2 major things, Your Lordship. First is plantation of trees, and the second one is transplantation of trees, Your Lordship. Among the whole highways, we will plant the trees among the 2 sides of the highways, Your Lordship. And the trees of the forest, which are more species, and we will transplant the forest, Your Lordship, which was mentioned in the page number 41 of the
council that you are doing as a part of polluter pay principle.
Your Lordship, the council states that during this whole project, we are following this policy, Your Lordship. Because this, that's only this project named as Greenfield Expressway Corridor Project, Your Lordships.
Continue.
Because all the Greenfield projects will comply with this highway policies, Your Lordships. And in that particular document, page number 33 explains about the transplantation of the trees, Your Lordship. In that, we have mentioned that we will definitely use the latest technologies for the transplantation of trees, Your Lordships. And for the for compliance with the forest conservation and local laws, it was mentioned in the 41, Your Lordship. Thus, before starting the project or cutting the trees of the forest, we will start the plantation, Your Lordship. Thus, this project named as Greenfield Expressway Corridor project, we are following the Green Highway policy. We have already started, it's impliedly meaning that we have already started the plantation of trees and we are complying with the environmental norms, Your Lordships. Highly obliged to Your Lordships. And Your Lordships, this post facto environmental clearance is also permissible, Your Lordship, does not prohibited by any legislation of the our country, Your Lordship. And in the case of Eldro Steel Limited versus Union of India and Pava Plastics versus Nastic NGO, as well as in the case of D. Swami versus Karnataka Pollution Board, in all three cases, the Supreme Court clearly held that this post facto environmental clearance does not prohibited by the Environmental Protection Act 1986, Your Lordship. And in any in exceptional circumstance, the any relief or even post facto environmental clearance can be given, Your Lordship. In many cases, like Alembic Pharmaceuticals and MC Mehta versus Union of India, and in much more cases,
which MC Mehta council?
Your Lordships. In the case of MC Mehta versus Union of India, 1987, SC 1996.
When your environmental impact assessment notification came?
Your Lordship, the first notification have been published in 1994, and after that 2000.
When was the case decided? How it is relevant council?
I'll oblige you to Your Lordships. But Your Lordships, in the case of Alembic Pharmaceuticals versus Union of India, as well as Eldro Steel Limited versus Union of India, and Pava Plastics versus Union of India, these three cases have been decided in 2021, Your Lordships. In that cases, the court clearly held that
yes, council, please take environmental impact assessment notification and make it very clear when you have introduced post-decisional hearing is one part of your developmental projects. Is it from 94, is it from 2006 or 2012, 2022 or 2023? Please open and say.
Your Lordships, we have the chance for the post-decisional hearing.
When you have introduced as a part of EAA process.
Your Lordship, it was an 2002 notification, Your Lordship.
Please open and read. Have you mentioned in your compendium which page or which flock it says?
Your Lordships, the council pleads ignorance, Your Lordships.
Okay, continue.
I'll oblige it to Your Lordships. Your Lordships, and the current document is submitted before this Honorable Supreme Court, this office memorandum we have been submitted, Your Lordship. In that, the project clearly states about the standard operational procedure, Your Lordship. In that, it can be mentioned that, first of all, the page number, the council pleads, page number 6, Your Lordships. In that, the appraisal under EA notification 2006, Your Lordship. In that, the project can be divided into permissible activities and non-permissible activities, Your Lordship. The permissible activities can apply for the post facto clearance, Your Lordship. Non-permissible activities cannot apply for the post facto environmental clearance, and we will close the project.
So now you have a clear indication in your notification itself.
Indeed.
Right? So similarly, when you have introduced post-decisional hearing is a part of EAA notification.
Your Lordships, in the case of Eldro versus.
No, I don't want a case. I want a substantial provision which you Parliament made. Or Parliament directed the central government to make rule under Section 3 of Environmental Protection Act 1986.
Your Lordships, we have given an post facto clearance process, Your Lordship. In that process, the scoping, public
council,
hearing.
all these four processes are learned counsel for petitioner did.
Indeed, yes, Your
Since you made a rule, it's there. Which part you have introduced post-decisional hearing may or may not be a part of EAA. Do you have a rule or not? If you have, you can cite, else you can skip and move.
Your Lordships, the council pleads ignorance, Your Lordship. I'll oblige you to Your Lordships. Your Lordships, in that particular document of the standard operational procedure, the activities have been divided to Your Lordships. Only a permissible activities can be applied for the post facto clearance, Your Lordship, as the facts itself says. Indeed, Your Lordships, indeed, Your Lordships. Your Lordships, and as far as the second ground concerned, I'll oblige you to Your Lordships. As far as the second ground concerned, the environmental process is also important for the environmental protection, as well as the economic process have to be maintained in the same hand, Your Lordship. It was mentioned in the case of Indian Enviro legal action versus Union of India, Your Lordship. Thus, whenever an irreparable harm is happening to the environment, then only the economic interest cannot be considered, Your Lordship. If the harm is irreparable harm, then the economic interest should be prevail, Your Lordship. In here. Your Lordships, the illegal reserve forest is only an reserve forest and not an protected forest, Your Lordship. Thus, there is no eco-sensitive area in it, Your Lordships.
Here the compromise is very clear. They are not coming to claim loss of resources. They claim their livelihood is affected. That's what they demanded polluter pay by referring principle 16 of Rio Declaration. Right?
Indeed, indeed,
Any
Your
irreparable injury, it is a duty on the part of a state to stop the project.
Indeed, Your Lordships. But here there is no irreparable injuries, Your Lordship. And as per the office memorandum we have submitted, there is 3 steps: damage assessment, remedial plan, and community augmentation plan, Your Lordship. Thus, we are complying with the polluter pays principle, and the damages have been caused by this construction have been given a compensation, Your Lordship, by this assessment, Your Lordship. Thus, if the court quietly convenes the second issue, the council seeks
Moot.
third issue. Highly obliged, Your Lordship. The third issue is whether the said construction of Greenfield Expressway Corridor project is in violation of Coastal Regulation Zone notification, and later on claiming exemption under post facto clearance is valid or not, Your Lordship. It is humbly submitted before the Honorable Supreme Court of Bharadam is that this claiming exemption under post facto environmental clearance, CRZ clearance, is valid, Your Lordship. Thus, the council seeks permission to submit this document before this court, Your Lordships. Your Lordships, with this document, I am here to prove that, Your Lordships, this project is comply with the CRZ norms while the project sites have been proposed, Your Lordship. Thus, in that document, page number 2, paragraph number 4, it states that whenever there is an specific recommendation shall be given by the CZMA, that is Coastal Zone Management Authority, then only the project proponents can apply for the post facto environmental clearance, Your Lordships. The specific recommendation only been given by that authority whenever the construction of an activity or the planning of the construction of an activity is complies with the CRZ norms, Your Lordship. As this project is applied, Your Lordships, your attention may be invited to the page number paragraph 18, paragraph 11 of the fact sheet, Your Lordship. In that, it was clearly mentioned that, Your Lordships, upon a completion of nearly 50% of the construction work by September 2023, based on the notification by the Ministry of Environment, Forest and Climate Change, which gives one-time remedy for the violators to apply for the post facto clearances, the government has applied for the post facto clearances, Your Lordship. Thus, only whenever... Indeed, Your Lordship. Indeed, Your Lordship.
You made a regulation by saying EIA has to be conducted.
Indeed, Your Lordship.
Right? So why you made a notification after completion of 50 projects? Who is Ministry of Environment, Climate Change, Forest?
Your Lordship.
Whose control ministry is?
Your Lordship, it was a control under the central government, Your Lordship.
Are you counsel for?
I'm the counsel for the government itself, Your
Then?
Lordship. Your Lordship, but this document has been introduced in the dated 19th February. Your Lordship, the council seeks permission to continue.
Yes, please, you can continue.
The dated 19th February 2021, Your Lordship.
Who issued this?
The government itself, Your Lordship.
Are you counsel for the government?
Indeed, yes, Your Lordship.
Then?
Your Lordship, but the contention of the council is that we are complying with the law of the land, Your Lordship. Because
the mere contention which was made by the petitioner applicant council where you made a regulation from 1994 in the name of EIA notification. You made a regulation in the name of Coastal Regulations of Notification 1994 wherein complied. You are happily saying you can vacate, then we will pay money. Therefore, they are standing their own fundamental freedom and livelihood is affected.
Indeed, no, Your Lordships. This project is only for the welfare of the people, Your Lordship. And in the case of NDJL versus Union of India,
okay, you leave alone NDJL, we don't want. Then which made you to start that ministry after the 50% of the completion of the project? Do you have any data with you?
Your Lordship?
Please read paragraph 11. Which made the Ministry of Environment, Climate and Forest to say post facto clearance may be? Do you
Your
have any
Lordship.
data with you?
Your Lordships, yeah, we have already published that post facto document in 2021, Your Lordships.
2021.
Your Lordships.
Right.
And in April 31, this document have been stayed by the High Court in the writ petition number 8866 of 2021.
April only 30, no 31. April is only, okay.
Sorry, that Lordships. That Your Lordships. Apologies for that, Your Lordships. Thus, only after the 2023, that case was dismissed by the same bench, Your Lordship. Thus, after that only we can get a chance to apply for the post facto.
This was dismissed by same bench.
By the Madras High Court bench, Your Lordship.
Okay.
This office memorandum have been stayed by the Madras High Court, Your Lordship, and in 2023 that petition was dismissed, Your Lordships. Thus, we can only apply for that post facto clearance in 2023. We have a chance to apply for that, Your Lordships, and this memorandum have been published before that, even before the commencement of the project, Your Lordships. Highly obliged to Your Lordships, and Your Lordships, in the case of Ennur Port Road compensatory versus MS Coastal, in that the NGT clearly held that the post facto environmental clearance is mandatory, it's valid, and this can be applicable for the project proponents which have public interest, Your Lordships. Your Lordship, this is a project which does not apply in a prior environmental clearance, Your Lordship. Indeed, yes, Your Lordship. Indeed, yes, Your Lordship. Indeed, yes, Your Lordship. Indeed, yes, Your Lordship. Your Lordships, without comply with an EAA notification and CRZ notification is not amount to the violation of fundamental rights, Your Lordship. Thus, we have acquired the land, and in the case of project, in the case of project proponents versus PV Krishnamurthy, in that case, the Honorable Supreme Court have held that the land acquisition can take place before the prior environmental clearance, Your Lordship. Thus, we have complied with the land acquisition without any prior environmental clearance. We can acquire the land, Your Lordship. Thus, it cannot be a violation of fundamental rights, Your Lordship. Highly obliged, Your Lordships. Thus, we have complied with all the laws we have created for regarding the environmental law as well as CRZ law. We have applied this post facto environmental clearance is clearly justiciable as well as valid, Your Lordship. If the court quietly convenes with the second and third issue, the counsel seeks permission to move on to the prayer, Your Lordship. Highly obliged, Your Lordships. Wherefore, in the light of issues raised, arguments advanced, and authorities cited, it is humbly prayed that this honorable court may be pleased to declare the land acquisition of Sengan tribes completely within the law of the land, and said project the construction of highways through the Idikal Reserve Forest does not violate the fundamental rights of the Sengan tribes. The said construction of Greenfield Expressway Corridor project without the requested environmental clearance and CRZ clearance is justiciable and valid. Thus, this project entitles to the post facto clearance, and kindly dismiss these petitions and pause any such order or direction that this honorable court may deem fit and proper in the facts and circumstances and in the interest of justice, Your Lordship. Highly obliged, Your Lordship. It's a pleasure to argue before this bench, Your Lordship.
Thank you, counsel. So we bench are learned many from you teams. Thank you. Yes, now it's a time. We'll clarify with them. Yes. Oh, what's the time is pending, ma? No. Now how much they exhausted? Okay. So, Sir Rebuttal? No, they have exhausted much time now. Okay. So can we give only 2 minutes each? 2 minutes each, sir. Already exhausted the last time. Yes. So I think you have exhausted more than 15 minutes. Okay. So we bench giving 2 minutes each. Okay. So don't repeat anything. Okay, whatever specifically clarified, if you have anything with you, you can happily note, right? Thank you. Please, please, please.
My lordships, the council here most humbly submits that the opponent council or my friend council has stated that
The learned counsel for the government.
begging pardon and convey my apologies to them also, my lordships. My lordships, as my learned counsel for the government has stated that this project is mainly for the public interest. If this project is mainly for the public interest, then they should have proceeded with the law, my lordships. They first applied for the superior facto clearance. After that, they can be initiated these proceedings, my lordships. Where my learned friend counsel for state has stated that they initiated this project as for the they initiated the post facto clearance as per the official memorandum which was given by the ministry, my lordships, where this council most humbly submits that the official memorandum has been stayed by this honorable Supreme Court. In the case of Vanashakti versus Union of India, when this honorable court permits, the council would like to submit the judgment copy.
Council, you haven't referred the same case, don't reproduce. Okay, Vanashakti case you haven't referred when you
Indian no lordship, the council has not referred. As they stated official memorandum, they followed the procedure of official memorandum. The council would like to submit this, my lordships. Much obliged, my lordships. My lordships, the council most humbly submits that official memorandum have been banned by the honorable Supreme Court in this case. When this official memorandum itself banned, the government has also constructed, even though this memorandum has been banned, the government constructed the project, which it concludes that they have contempted the honorable court, my lordships. And the council would also like to submit that my learned friend council has not answered anything about the elephant corridor, my lordships, where this earth is also for the animals. It is also the direct duty of the government under Article 48 of our, my lordships, kindly grant 2 more minutes, 1 more minute, lordships. Much obliged, my lordships. It is the duty of the government to protect the environment and wildlife too under Article 48A of the Constitution, my lordships. My lordships, and the final rebuttal is, my lordships, the council conveys this with a heart full of sorrow and pain, representing the Senjan tribes, my lordships. As my learned friend council has stated that the rehabilitation and compensation is in consulting procedure, my lordships. My lordships, the council would like to interrupt that the project has been initiated in October 2022, which has been stated in the Moot proportion, my lordships, where the date today is 4/2/2024, my lordships. They are consulting this. They are consulting the fair compensation. They are consulting the rehabilitation for more than one and a half year, my lordships. Think our life for this 1.5 year, my lordships. How we have suffered for the livelihood. How we have suffered for the life, my lordships. My lordships, the council on behalf of the Senjan tribes have lost their hope on the government and have only hope the honorable bench, that the honorable bench of 5 judges, constitutional bench, will not leave us. Much obliged, my lordships.
Thank you.
Much obliged.
Please.
Lordship, am I audible, my lordship? My lordship, as per my co-counsel said, the Vanashakti has stayed the environment clearance, my lordship, but the stay has dated on January 4, 2024, but the application was made on September 2023, my lordship. So retrospective effect cannot be taken into account, and as already stated, the fundamental rights have not been violated, my lordship. We are planning for the rehabilitation process in the Idikal region itself, and the highway project is a greenfield expressway corridor project. Therefore, right to environment has also been not violated, my lordship. My lordship, it is crucial to note that, Lordship, please refer page number 29 of the appellant's memorial, my lordship. My lordship, the appellant has quoted CRZ in 2019 notification, my lordship, but Thai Nadu has just applied for the CRZ mandate project, and Thai Nadu is not applicable for CRZ 2019 notification, my lordship. So CRZ 2011 notification, the government has applied under that and should have been argued under that notification, my lordship. So this proves that the learned counsel for appellant is unaware of the laws, and thus the fundamental rights are not violated, my lordship.
I think the last statement is not acceptable.
Statement he made, you state failed to exhaust Article 48 capital A.
Council, you can't criticize the
Apologies for that, my lordship. The council here says that
you can't say that particular.
Indeed, my lordship. The arguments regarding issue 3 was regarding CRZ notification 2019, my lordship. So it cannot be justiciable under CRZ 2009 since it is not applicable before this bench, my lordship. So since
No, they have 1,000 remedy instead of 0. If they put 1, it may be correct. How you will say they don't have a knowledge of law?
Apologies for that, my lordship.
Don't
The
say,
council has the contention that the issue 3 cannot be said as justiciable since 2011 notification should be contended, my lordship. So 19 is not applicable in Tamil Nadu. It is only applicable for 4 states, my lordship.
Okay, have you failed to perform your constitutional duty, what they mentioned, 48 capital A?
Indeed, my lordship. Here no constitutional rights are violated, my lordship.
No, not a constitutional duty to protect elephants.
Indeed, my lordship.
48
My
capital
lordship,
A.
under elephant corridors, the council would like to submit the pay flag number 2 of the compendium, my lordship. My lordship, we have submitted lots of data that the highway does not violate the elephant corridors and the highways are in public interest, my lordship. Please, the many data have been submitted before the compendium, my lordship.
Okay. Thank you.
It's a pleasure arguing with those friends, my lordship.
Thank you. No.
Submission is done.
That's all. So, after that you can discuss. Okay, good.
Students and participants, please move for lunch and come for the valediction as soon as possible to the video conference. And both the teams. Team buddies, take to the lunch.